We are always live on our YouTube channel, Mwangaza TV Kenya. As I have told you, I am Celestine Waka, the favored. Karibu sana wakili in our today's show. This is where we unpack to bring it to our viewers' doorstep. Today we talk about the data protection. Maybe if there's something I haven't mentioned in the introduction, yes. Kindly introduce yourself to us. Yes. Let us know you even as we delve into our today's show.
Thank you very much, Celestine.
Yep.
Let me take this opportunity to thank you for a chance to demystify data protection,
yes,
and to also participate in my advocate's duty to the public,
yes,
to help our people and even organizations to understand what data protection means, what are the do's, what are the don'ts,
yes,
what are the opportunities and dispute resolution mechanisms.
All right.
So as you rightly introduced me, my name is Anthony Nganga. I am a privacy counsel, and I am also the managing partner of Nganga Muthoni and Company Advocates,
yes,
where we serve both individuals and organizations when it comes to data protection and many other aspects of the law. The only thing that I would like to add from your introduction,
yes,
is that we are living in a global village, and data protection obligations and compliance requirements are not only within the Data Protection Act. We have global regulations that have reach even within the country. And the most progressive data protection legislation is the General Data Protection Regulations in the European Union, commonly known as the GDPR. So I'm happy to unpack this.
Thank you, and thank you for your time once again. Just as you've heard, let's get into our today's topic,
yes.
Data protection. When someone speaks or talks about data protection,
yes.
what does it mean?
Thank you very much. Data protection is actually a constitutional principle.
Okay.
It has its genesis and its foundation within the Constitution, and I'll mention three critical constitutional provisions.
Yeah.
The first one is Article 28 of the Constitution, which provides for the right to human dignity. The other right is the other constitutional provision is Article 31, which is the right to privacy, and Article 35, which is on the right of access to information. The genesis of the data protection legislation is that there are certain details and certain information about us that is private, and this information ideally and naturally should not be disclosed, should not be collected, should not be stored or even processed anyhowly.
Okay.
That's how I can simplify it.
Yes.
So when it comes now to data protection, is Data Protection Act in Kenya. It now provides the legal and institutional framework to help personal data,
yes,
and to even place certain obligations on individuals and organizations that deal with personal data to ensure that they are dealt with within the principles of data protection.
All right.
Yeah.
So when we talk of data protection, some of the data that needs not to be, given out,
yes,
or displayed for public use or whatever.
Yes.
What are some of these data,
yes,
that needs to be protected?
Thank you very much. So according to our Data Protection Act, there are two categories of personal data.
Okay.
And the first distinction is that Data Protection Act is about personal data. It's not about company data or organizational data.
Okay.
For example, the legal entity that owns this station, that's not a natural person.
Yes.
So it's about a natural person. It's about you, Sele, as a presenter,
yes,
and as a human being.
Yes.
So that's the first distinction that we need to get. Then personal data is categorized into two.
Okay.
There is personal data, personally identifiable data.
Yes.
That's the first category. And the second category is sensitive personal data. And the safeguards that are expected by the law are different for each of these categories. So for personal data, this is information that either identifies you as an individual,
okay,
or information that can be used to identify you. For example, your name,
true,
your telephone number, your national ID card number. You know, that is personal data because it identifies you,
yes,
and it can also be used to identify you.
Yes.
The second category is sensitive personal data. Now, this is information that is over and above, you know, that is over and above the personal data because it comes with some level of uniqueness and sensitivity around it.
Okay.
Information, for example, about your family matters. Okay?
Yeah.
Information about your children, your spouse, or your partners, and all that. Information about your health records. Your information about your even certain positions on sensitive matters. For example, your stand on LGBTQ.
Yeah.
For example, your stand on certain sensitive matters is also very sensitive, and there are higher safeguards expected when dealing with sensitive personal data. Also, property details. Property details are also sensitive personal information. Yeah.
Why is it so important for us to secure this data?
Yes.
Or maybe if I have to use the higher classification, why is data protection very important?
Yes.
To me as an individual.
Yes.
Yeah.
Two reasons. Number one, we are living in the fourth industrial revolution.
Yeah.
And it's all about data.
True.
Decisions are being made over data, using data.
Yes.
And the first importance is to safeguard our human dignity, because there are individuals and even organizations that hold very sensitive data about you and also about me. Without legal framework, that means that these organizations can misuse, can mishandle, and some can even commercialize this data without your knowledge. Okay?
Yeah.
And that is the reason why we are greatly and very critical to have this information, because it even shows integrity, even in business. There are certain investors that cannot invest in a company that is not compliant when it comes to data protection. So it helps us safeguard human dignity. That is number one. Number two, it is a show and proof of integrity and responsible business when it comes to business with two organizations.
Yeah.
Number three, and very importantly, is that it dictates the kind of data that can be collected, how this data is to be collected, how it will be stored, and how it will be processed. You know? And that gives the power to the data subject. And the data subject is you and I, the owner of this personal data. So it seeks to leverage the playing field.
Are there principles that govern data collection?
Yes, there are.
Okay.
There are, and I would mention, the most important four of them. Number one is purpose limitation.
Okay.
All that means is that if today I give you my contact as if you are a doctor, or you are a hospital,
yes,
and I come to you and give you my information for purposes of treatment, you are not allowed to use that information for any other purpose, unless if you have asked me and I have said yes, I am agreeable with that, or if you are legally justified to use that information in that other purpose. That's number one, purpose limitation.
Before we move on,
yes,
what does it mean for someone to be legally?
Yes, thank you. There are certain exemptions.
Okay.
For example, a hospital may use your data, or a hospital may give your data to the Ministry of Health.
Okay.
Probably that is part of the statistics or regulatory obligations that that hospital has in that respect.
Okay.
All right?
Yeah.
So can we move to the second one?
Yes, we do, please.
The second one is the second one is lawful basis.
Okay.
That when I'm collecting your data or when I'm using your data, there has to be a lawful basis for that.
Okay.
For example, if we are entering into a contract and you need my KRA pin,
yes,
you need my ID number, so that you can probably perform your part of the bargain. If you are employing me, you need to pay my payee and all those other details. So that is the lawful basis. Without a lawful basis for collection, storage and processing of personal data, you are not allowed to collect that data. The third principle is data minimization. What does that mean? As much as possible, only collect the information that is necessary. Okay?
Yeah.
If you don't need information about my family and my children, don't collect.
True.
You get?
Yeah.
Okay? And if you don't, that is when it comes to data minimization.
Yeah.
The last one, or the fourth one, is storage limitation.
Yeah. Yeah.
We have certain legislations that dictate the periods within which you must be you do retain personal data. So then, as a data controller, or as an organization or an individual who is collecting and dealing with personal data, you must ensure that you do not keep my data, or you don't keep the data subject's personal information beyond this time limit. In most cases, it's 7 years from the date of the termination of the contract. That is the legal threshold in Kenya. So again, but there could
7 years is a long time, though.
It is a long time, but that is what we have in the Limitation of Actions Act. But if there are other provisions that provide for shorter period, then that is what is applicable, because you see sometimes it's sectoral. Maybe the limitations within the communication sector could be lower, or even longer. Yeah.
All right. Maybe before we take a short break.
Yes, please.
Does the same rule apply to, let's say, the offices where you're walking into an office and you're told to submit your ID? There are things you need to note down, your telephone, your contact, your ID number, and you leave your ID there, your physical ID there.
Yeah.
You walk, do whatever you have to do, and then come back, pick your ID, but the data remains there.
Yeah.
Does the same the regulation affect?
Apply,
yes. Apply in such cases?
Yes, it does apply.
Okay.
And one of the biggest shortfalls and shortcomings, and some of the things that necessitated enactment of the Data Protection Act in 2019 was around, number one, digital credit providers or digital lenders who are collecting and misusing personal data. Number 2, property management companies, and actually, for your information, all property management companies are required to register with the Office of the Data Protection Commissioner as a mandatory requirement. Okay?
Yeah.
Because I will talk about registration and certain obligations that, that entities have. So, property managers are part of the 10 categories that must get registered with the Office of the Data Protection Commissioner. Now, one of the shortfalls or one of the disadvantages of manual collection of data, of personal data, is that right now the details that you put in a book, you don't know who has access to that information. You don't know if someone can come and take a photo of that information and send it to I don't know where. You've left your ID number, you've left your phone number, you've left your name. In other places, you are even leaving your email addresses. Some are even collecting details about where you are coming from, where you live, and all that. So again, we see a lot of possible breaches when it comes to personal to the data protection requirements. So all property managers and business owners are encouraged to consider innovative approaches to achieving the same objective, because there's a good reason why that information is there. It's number 1, for security reasons. Okay. Number 2, if anything was to happen in that building, how would they know the people who are inside there? You know, so there is a good reason to do this. But then we must do this. We must collect this information in a manner that is consistent with privacy rights and the Data Protection Act. So we are seeing organizations innovating. There are systems that help property managers and premises owners to be able to collect that information in a very in a manner that is consistent with the law, and we are helping them as part of the services that we provide, advising them, helping them register, helping them put in place the right processes and procedures when it comes to collection and management of personal data.
Wow, indeed, in a digital world where our data matters a lot, you must secure it and make sure that it remains safe. We shall be taking a short break, and I'll be back with Advocate Nganga. And of course, we have to unpack and make sure that we fully understand what it takes to have your data breached or protected, to have your data out there or by yourself. Don't go away. This is Legally Speaking Show. All right, welcome back. We are still in Legally Speaking. Remember, this is where we make the law speak your own language you're able to understand. And today we are trying to unpack. Actually, we're not just trying, we are unpacking the data protection, all that we need to know about data protection. It is now with us in studio. As I had mentioned, I have Advocate Anthony Nganga, a member of the Data Privacy and Governance Society of Kenya, and is also a champion for both individual rights and organizational accountability when it comes to handling personal data. So before the break, we had actually tried to analyze the kind of data that needs to be protected. We had categorized, and we actually looked at the data breaches, which we are also going to delve into more. Just as I've told you, 22914 is our SMS line, Facebook page Mwangaza TV, and our YouTube channel Mwangaza TV Kenya. I'm still your host, Celestine Waka the Favored. Welcome back on board, Wakili. Welcome back on board.
Thank you so
much. We continue to unleash, to unravel all that is there for us to know. I want us to look at the legal framework.
Correct.
When we are talking about the data protection, what is the legal framework?
Great.
Yeah.
In terms of the legal framework, we are looking at the laws.
Okay.
And we said that we would start with the Constitution of Kenya.
Yes.
What that means is that privacy and data protection is not a matter to be taken lightly.
Yes.
So it has a constitutional underpinning. All right?
Yeah.
What that means is that even before enactment of the Data Protection Act in 2019, these rights were already enshrined in our constitution.
Okay.
From there, we got that's locally, we got the Data Protection Act in 2019.
Yes.
And several regulations have been issued thereafter.
In regards to the same.
Something also very important, and we must, applaud the Office of the Data Protection Commissioner, is that they've gone a step further to issue sector-specific guidelines. Say, for example, for entities and individuals within the education sector. By understanding that the nuances, within the education sector may be different. So there are sector-specific guidelines on that. Institutionally, in Kenya, the Office of the Data Protection Commissioner is as the principal government agency that deals with data protection. Okay?
Yeah.
And then from there we move to the dispute resolution process.
Yes.
Additionally, we also have the Office of the Ombudsman. Remember, we said that we are entitled to access information.
Exactly.
And that is part and parcel of privacy rights. So if an organization has denied you access to information,
yes,
or if you have any dispute within the Access to Information Act, then you can lodge that to the Office of the Ombudsman. And the full name is the Office on National on Administration of Justice.
Yes.
CAJ, Commission on Administration of Justice. Now, those are the two institutions. If you are still not, and then the third level are the courts of law. Remember, you can always approach, our courts when you have a dispute touching on privacy rights. However, and this is now when we move into dispute resolution.
Yes.
What do I do as a person if I am concerned or I have a dispute or a complaint about how my personal data is being handled?
Yeah.
The starting point is to lodge a complaint to that person or that entity that is handling your data in the wrong way.
Okay.
This can be done through a demand letter or even through an official communication to them.
Yes.
Then if you are not agreeable or if you are not happy with how they handled your complaint,
yes,
then you should move to the next level. You go to the Office of the Data Protection Commissioner. You lodge your complaint.
Yeah.
And you may engage a lawyer to help you in structuring that and positioning it.
Yeah.
And you can also do it personally because it's done online.
Okay.
You can lodge your complaint with the Office of the Data Commissioner and they will review and make a determination. Good thing is that they make a determination within 60 days. Okay. All right? If you are not agreeable with the determination made by the Office of the Data Commissioner, then you can go to High Court and appeal the decision. Okay. Please note that as a country, we are governed by the rule of law. And when you make a complaint to the Data Commissioner, the other party must be given an opportunity to respond or to answer to the claims. Okay. And then that is what will inform the ultimate decision by the Office of the Data Commissioner.
All right. Yeah. So before we move forward, because there are several things I would want us to talk about, I was just listening to you talk about someone who is about to launch a complaint because his or her data has been mismanaged. Are there bodies within now, as being in Kenya, are there bodies that can access your data and use it without your consent?
Thank you very much. Consent is one of the bases for processing personal data. But consent is not the only basis.
Okay.
So there are some circumstances where access and use of personal data may be allowed. So they are called, they are known as exemptions.
Without my
knowledge. They are called
knowledge.
exemptions.
Okay.
Okay?
Okay.
And one such would be for journalistic purposes. If you are recording, let's say, a demonstration, and you capture my face when I'm doing that,
yes,
and you air it within that context, that would be allowed.
Okay.
All right?
True.
If the police are looking for me,
okay,
as a suspect, you know,
yes,
again, that is when it comes to
allowed.
Say national security.
Okay.
So there are several exemptions that would be allowed. The other important thing that you will need to know is that very important, especially for organizations. We need to understand, and the main question that we should always be asking ourselves is, what is the basis for my collection and processing of this person's personal data? Okay?
Yes.
As long as you have a legally justifiable basis, you would be allowed to process personal data. So consent is just one of the bases. Yes. Right. And again, please allow me to say what is consent. Because that is very important for us. The law has placed three test threshold.
Yes.
Number one, consent must be informed.
Okay.
Okay? I must be aware of what is it that I am giving my consent to. That's number one. Number two, it must be very express, not implied, not something that you are trying to look for, I don't know where. You know, it must be very express that I'm saying I am agreeable to the collection and processing of my personal data. Okay? And number two must be unequivocal. Number three, it must be unequivocal. Unequivocal means it must be so clear that there is no other way of interpreting it.
Wow.
It must be clear that I am saying that I am agreeable. Not that, okay, it can be interpreted to mean either way. So when your basis of processing personal data is consent, you must ensure that those three conditions are met, and that you can be able to demonstrate that the data subject, and the data subject is the owner of this personal data, was adequately informed. Number two, that their consent was express. Very express. And number three, it was unequivocal. And this is one of the challenges that organizations do find themselves in, where for you to access certain services, you must say yes. That has been determined both in Kenya and even in the European Union not to be sufficient consent. Yes.
Okay.
It has been determined not to be sufficient consent because my access to certain services is pegged on my consent. Yes.
Wow. We've had issues, more especially in Kenya. Let's talk about Kenya because I know this is something that is happening all over.
Yes.
We've had issues with hackers, cyber crimes, and what have we. People accessing our data sometimes without our knowledge, and you realize your systems, your platforms have been hacked. When we are to talk about data protection in this context, who is liable?
Who takes the ultimate responsibility?
Exactly, yes.
That's a very good question. Now, two things that I would like to say here.
All right.
Data protection does not exist in isolation. It intertwines, and there is a great nexus between data protection and cybersecurity. There is a great nexus between data protection and technology
Yes.
and innovation. All right?
Yeah.
So in terms of responsibility and accountability, you as the owner of this personal data, there are certain responsibilities that sit with you. For example, some of this personal data, we give it out so easily and so willingly. If I decide today to parade my home,
Yes.
I decide to parade my family,
And
I
your
decide to parade my my personal information today,
Yes.
through social media and all that. While any hackers may not be authorized to use it, I have given them an easy access.
That's true.
So the point is, we must also be very responsible and accountability at our personal level. Okay?
Yes.
That's the first layer. But now, when it comes in terms of responsibility and accountability, when an organization is involved in collection of personal data, there are two critical concepts that they must have in their compliance program.
Okay.
Number one is privacy by design. What does that mean? That they have technologies and systems and technical interventions that ensure that personal data is protected.
Okay.
Technologies. For example, organizations do have user access management.
Yes.
That the only person who can log into our systems
Yes.
and access is our employees. Okay? And they put in place mechanisms to ensure that the threat of cybercrime, hacking, is put away. So that is privacy by design. The second critical principle is privacy by default.
Okay.
What does that mean? That means that the way our organization is wired, from our people, processes, and systems, we lean towards privacy. Okay?
Yeah.
That our actions, our culture, our processes are wired towards privacy and upholding data subjects' rights within the data protection context.
Okay.
So if as an organization you have failed to put in place those two critical principles, then you open yourself up to litigation and even fines and penalties. Because when people or when data subjects complain,
Yeah.
either through the Office of the Data Protection Commissioner or even through the courts of law, we've seen companies and entities being penalized on data protection gaps and breaches.
Exactly. When we talk about the penalties, maybe at an individual level
Yes.
or at a company's level,
Yes.
what are the penalties,
yes.
especially when one is found guilty?
One is found culpable.
Yes, culpable.
Now, we've seen different cases
Okay.
where different awards have been given. And they range all the way from 250,000 all the way to, I think the highest was around 4.5 million, but that was for many offenses.
Yeah.
Okay?
Yeah.
But over and above the monetary penalty, there's also a reputational issue, reputational risk.
Yes.
Because let me ask, who would want to do business with an organization that is being found to breach people's privacy? You understand?
Exactly.
So we need not look at it solely from the monetary cost. We also need to look at it from the reputational, angle. Especially now in this digital era, I wouldn't be surprised if when say for example a hospital mismanages personal data,
Yes.
that information goes all the way, finds itself in the social media,
Yes.
and there is a hashtag. Avoid hospital ABCD. They misuse your personal data. that is a whole wildfire that you may not be able to may not be able to contain. Yes.
Yeah. Wow. So even as we come to the wrap of our show, because I know that there are people out there who are watching us today, and maybe their data has been breached.
Yes.
So they have been, they have found themselves in places or in situations where their data has been compromised. And maybe because we go in each and every office in these organizations, we are meeting up with these people, we are online, and sometimes you may not even know where exactly. These, we are not able to trace back the data and establish exactly when this data was collected or picked. Maybe is there something that kind of cautions, my data on all my online platforms, just to make sure that maybe it's safeguarded?
Thank you. Thank you so much. Two things that I want to mention here, very important. And part of our sensitization and awareness programs is to tell people, your data, your personal data, is your responsibility. In the first place. You must be very keen on how you access, how you share your information. You must also be very keen on how you safeguard your personal information at a personal level first. All right? That's number one. Number two, for organizations and individuals that are dealing with personal data, you must, as a matter of priority, make sure that you understand the legal and regulatory framework when it comes to data protection. Is your company required to be registered, for example? Is your company required to have data protection policies and privacy statements? Is your company required to undertake staff training and awareness? And are you doing all these things? Because the problem that we are finding, and some of our clients have found themselves in hot soup, is where a complaint is lodged with the Office of the Data Protection Commissioner. And then they reach out to us and tell us, there's this complaint, we don't know what to do. When we come in, we find that this entity should have registered in the first place. This entity should have appointed a data protection officer. This entity should have been put in place policies and procedures, systems and technologies, but they have none. It becomes very difficult to defend yourself before the Office of the Data Commissioner. And the joy is, you do not have to wait until that moment. And in one of the conversations that we were having with my colleagues in the privacy profession, someone said that some Kenyans are using data protection as, in Swahili, kitega uchumi. And we cannot blame them, because if the law protects your data, your personal data, it would only be justifiable to enforce your rights when you find yourself in situations where your data has been breached. So the message that we are spreading to organizations, if your company has a turnover of 5 million and above, and you have more than 10 employees, you are required to be registered by the Office of the Data Protection Commissioner. However, there are certain industries that, regardless of your turnover and number of employees, you must be registered. And we can mention a few, and there are actually 10 of them. But they include, number one, in the education sector. Number two, financial services. And this includes banks, digital lenders, insurance companies and their agents and all that. Number three, we have property management companies. We also have betting companies and some more of them who are required to mandatorily register. And registration is not an end by itself. You know, over and above registration, you need to put in place a data protection compliance framework to ensure that you are compliant. And even if an issue was to arise, you would be able to demonstrate.
Yes.
And we've helped many companies to evade the issue of fines and penalties.
Yes.
Because they are able to demonstrate that these are the safeguards that we have put in place.
Yes.
You know? And this is how we handled that matter. This is our dispute resolution mechanism and all that.
All right. So your final remarks as we wrap up, and as you give us your final remarks, you can quickly mention whether you are available for consultation or any other thing.
So, thank you very much. My final remarks, and I will have two comments. Comment number one is your personal data is your personal responsibility. And number two, for organizations and individuals who are handling personal data, please make sure that you have educated yourself about the obligations that are there, and that you've put in place necessary safeguards to protect the personal data that you do collect and handle. Finally, data protection for businesses is not meant to impede business or to make it difficult for organizations to go about their business and operations. The only thing that data protection requires is that organizations are putting in place appropriate safeguards to protect personal data that they do collect.
Okay.
Are we available for consultation and legal services in this area? Yes, we are. And we are located at Wood Avenue in Kilimani, Ushuru Sacco Center on 5th floor. And in terms of our contacts, you are able to reach us through the following telephone number: 0715 387 308. 0715 387 308.
Thank you.
And our email is info, that is INFO, at ngangamudhoniadvocates.com. We would be happy to listen to you and to help you navigate the privacy landscape.
Wow. Thank you so much for creating time to be with us. And there you have it, a deeper dive into the Data Protection Act. We've been able to understand fully what it takes to know, identify, protect, and make sure that you are measuring or giving a measure to what exactly we need to know about you. Because as the Mr. Nganga has told us, you are to be liable. You are the first person to protect your own data. And remember, this is Legally Speaking show where we always unpack the law and bring it at your doorstep. It is not late. In case you've missed out on any of our episodes, remember to follow us on our YouTube page, Mwangaza TV. We always stream live, and this is a show that comes to you every Monday from 7:30 p.m. with me, Celestine Waka the Favored. And if there's a title, a topic that you'll want covered, kindly hit my inbox, reach us out. You can do an SMS on 22914, and we will definitely get someone to do the informative narration and explanations to us. Until next time, I am your host, and it's always my joy to have you on board every day. May the Lord bless you and do you well. Ukiwa na maoni